we are live, and this is Rice Hitenga versus Yanni et al., docket number 18-272NH. And this is the defendant's motion to amend witness list. And you can put your appearances on the record. I would just add the plaintiff.
I don't hear you coming through the speaker.
Hold on, we have a technical issue.
Just turn it off, turn it right back on, sorry.
Okay, we've got to reboot the recording system, so it'll just take a minute. No?
No, hold on. Let's see. Okay.
Okay. So this is the defendant's motion to amend the witness list. The plaintiff does not oppose the amendment, but the plaintiff wants to add a potential rebuttal witness to the plaintiff's witness list. And Mr. Van Erp, this is your motion. You can go ahead.
Thank you, Your Honor. Michael Van Erp for the defense. You pretty much hit the highlights. There's not a lot to add. I think my motion establishes good cause to substitute our expert, because an expert who originally agreed back in almost 3 years ago to review the file has now been told he's not allowed by his employer because of the circumstances we're living in. I'm just asking to substitute someone with similar credentials who is readily available to look at the file. As far as plaintiff's response and the request to add an expert on their part, my comment in that regard is if the court would allow that, then I would ask that the defense also be allowed to name an expert, because that's bringing up a new specialty that neither side has named experts previously. And that's all I have, unless you have any questions.
I don't. Mr. Carley?
Yeah, Your Honor, we would either, we're not exactly sure what their experts are going to say as we're just getting into their causation experts. During negotiations, which are continuing almost weekly, they brought up something about general anesthesia in the CCU, potentially, or in the operative room, and something in the CCU that could have happened. You know, we don't see that. They didn't list any anesthesiology or critical care expert witnesses. We didn't either. As these, I mean, I think this is sort of a, you know, something out there as to a possible defense, but we don't want to be caught. We don't have our agents who are critical care doctors and anesthesiologists. And I know I would just like to, I don't think the expert, whether being I think I said anesthesia or CCU, you know, I don't anticipate he's going to be or she's going to be in our case in chief, but I don't know what exactly their experts are going to say. And like I said, we don't have our built-in doctors who are CCU and anesthesiologists. So I'd like to add a physician as a rebuttal witness, which I'm not sure even under Michigan you have to list them as rebuttal witnesses. I know that I actually did list rebuttal witnesses one time in another case before you, and they challenged that, and you said no, these are fine. But like I said, we haven't listed one, and that's it. You know, it's you know, within the discretion of the court, of course. I don't, whichever way you go with us, I'm not objecting to them adding Dr. Kelly in this case, because I don't know. I think that they've worked with us and worked with me on other cases before, and so they're fully entitled to that. I don't think they don't. I know the physical medicine and rehabilitation physicians they have listed have not seen the patient, so they're not shopping around for a better expert or anything. So like I said, I have no problem with that at all.
All right, thank you. Mr. Van Erp, any last words?
Just briefly, if we're talking rebuttal, I think when we talk expert witnesses in rebuttal, I think there does have to be some advanced disclosure that a particular specialty might be used as a rebuttal witness. And if we go down that path, I don't want to be surprised at trial by Mr. Carley calling a rebuttal expert who we didn't realize existed. And that's all.
Well, all right. There's absolutely good cause to make the substitution on the defendant's witness list. That's really not an issue. As far as a potential rebuttal witness, there's no way the defendant can be surprised by a rebuttal witness because the very nature of a rebuttal witness is to respond to something that the defendant put on in the defendant's case. And that's a legitimate use of a rebuttal witness. It does not necessitate allowing the defendant to add a witness because that defeats the whole reason that you have a rebuttal witness. The rebuttal witness responds to something that the defendant has already put on. And if the defendant doesn't put on some witness or evidence that directly relates to this proposed rebuttal witness, then the rebuttal witness can't testify because it's not a proper rebuttal witness. But I would, and I'm not sure that there's any authority, no one's given me any, for having to list a rebuttal witness, but I am granting the defendant's motion to amend the witness list, and I'm granting the plaintiff's request to add a potential rebuttal witness to be used only as a rebuttal witness and limited by the purpose of a rebuttal witness if it is necessary to call that witness.
And that would be, Your Honor, like I said, I don't know. I think I mentioned an anesthesiologist. I don't know what they're going to say, so it could be an anesthesiologist or CCU doctor. But anyway, I understand your ruling.
Okay, then that will conclude our hearing.
Okay, thank you, Your Honor.
Thank you.
Okay.